Welcome back. Our next session is on landlord-tenant law, and as with so many other programs that are planned far in advance, changes happen. And I thought originally we'd be spending a lot of time on the new Cook County tenant landlord ordinance. I think theirs is, and Chicago is the residential landlord tenant ordinance. In any event, our speaker will cover that, but we've also have a lot of information on eviction moratoriums and what's going on in the courts, et cetera, et cetera, et cetera. Jack Bailey is going to fill you in on those details. Jack actually started his career in the criminal law field. That's right. And spent time at 26th and Cal, went to the Attorney General's office, and more recently has been doing landlord-tenant work, and especially with our friend Adrian Zeno, who is now relocated to Florida, and Adrian was kind enough to recruit Jack to fill in. So without further ado, Jack Bailey.
All right, thank you, Mike. Good afternoon, everyone. So, I'm lucky enough to be here because of Adrian Zeno. I've known Adrian for at least 12 years, but he called me out of the blue in February and asked if I'd partner with him and handle evictions. I said, of course, I love Adrian. So we have a partnership and going forward. So we're trying to help landlords maneuver through this really kind of confusing time that we've been in, right? And so that's why I'm here, and I'm very happy to be here. Typically, when you talk about any kind of an update at one of these seminars, you just expect maybe the discussion of one case or, a slight change in the statutory law. But boy, talk about an update. For the last 16 or 18 months since the pandemic started, the laws, regarding many things, of course, have changed, but particularly in evictions. There's been a thought that evicting people during the pandemic is going to exacerbate the problem, that people will become homeless and more likely to contract COVID or be forced to move in with family members in closer quarters. So everything seems to have been done. Many different agencies, as you'll see as we talk, have put their finger in here, put their hand in, and have influenced how evictions are proceeding right now. So I'm going to just real briefly, because it's been a monumental chore actually over the last 16 months to keep track of all the different changes that have affected eviction cases and how they go forward. But I'll just do a real brief summary because it really only matters where we're at now, right? So the first case, I did a Google search of COVID-19, was in January 21st, 2020. The stay-at-home order by the governor was March 20. It's right around that time, I know in Cook County at least, the courts closed. April 7th of 2020, the Supreme Court suspends all trials until further notice. And on April 23rd, the governor issued the eviction moratorium. And it was a blanket prohibition against the commencement or the executing of a eviction order. It was blanket. It wasn't just for non-payment of rent. It was for any reason, month-to-month tenancies or, breaking the conditions of a lease. However, and this is up till today, this is still the case, there is one exception, and that is the health and safety exception. And I'm going to talk about that in a two slides coming up. So one thing, and I don't know who, to what extent everyone knows this, but as we sit now, any kind of prohibition on going forward in an eviction has to do with what's called a covered person. And a covered person was defined back in November of 2020. And there's a definition that was lifted by the state of Illinois from the CDC definition of what's a covered person. Once a person is declared a covered person, that's what puts the brakes on any further eviction action. So it matters whether or not a person is a covered person as far as the moratorium, and especially right now. So in November, when they did this covered person, it really, in a sense, opened up the gates a little bit because it then allowed evictions to take place on month-to-month tenancies and 10-day notices and the like. But, so let's talk about what a covered person is. So there's a requirement in Illinois, and it's still in effect now, that if you're seeking to evict a tenant for non-payment of rent, prior to giving them the notice of termination or 5-day notice, at least 5 days before, you need to serve, in the same manner that you would serve a 5-day notice, what's called a declaration. And then what a declaration, I have it somewhere, a declaration is a 2-page document, and the first page explains what the second page is. What the second page is like an affidavit of sorts that a tenant can sign and attest to. And if once they do that, they are afforded the protections of a covered person. And even up until today, there's a prohibition against enforcing and going forward on against covered persons. And we'll talk about that and where we're at right now in a minute. But here's the questions that they need to attest to. One is that they make under a certain amount, either $99,000 as an individual or $198,000 as a couple. They're impacted by COVID-19, something relating to COVID-19, a loss of job, less income, caring for a COVID-19 patient, or whatever. For whatever reason, they're having trouble paying rent. That's the second attestation. The third one is that the tenant has to say that I am making my best efforts to make timely partial payments that are as close or as full as the full amount. That's hardly ever the case, but it gets signed. And then also the last one is if evicted, I would become homeless or I'd be forced to move into close quarters. So once they sign this declaration and tender it to the landlord, it puts a halt on anything else going forward, including serving a 5-day notice, which is arguably the commencement of an eviction. So that's what a covered person is. So so an exception from the moratorium would be that you've given the declaration to your tenant, but they fail to respond within 5 days. At that point, you can give them a 5-day notice, and if they fail to respond to that, of course, then you can go forward on an eviction. At that point, they're a non-covered person if they fail to respond and sign the declaration. However, more recently, the governor has extended the protections of the declaration. At any point in the process, probably up until the point of being evicted, a non-covered person, if it's for non-payment of rent, can tender a declaration at that point, and that will put a stop to anything going forward, regardless of where it's at in the process. So the health and safety exception, which has been with us ever since April 2020 when the moratorium was first announced, it's being used a lot actually. So, and let me, here's the definition of what constitutes a health and safety exception. If a tenant poses a direct threat to the health and safety of other tenants or an immediate and severe risk to property, and even if they're covered, they are exempted. It's an exception. And an eviction can go forward, claiming that they pose this serious, health risk to other tenants or to the property. So, but what's kind of interesting about this, there's no statutory provision for this. This is from the governor. What I think courts are grappling with, and some judges are, I know, because I've heard them talk about it, is this a new basis for an eviction that's going to be going forward? What happens when the moratorium is over? What happens to these health and safety complaints? And at least one judge that I've heard, who I think is really good, he says this doesn't create a new exception. What this is the 735 ILCS 59210, which is terminating a tenancy for defaulting on the terms of their lease or breaking a condition of their lease, and then giving a 10-day notice. So he, first of all, requires in these health and safety exception cases that the tenant has been given a 10-day notice. because it's his position that this does not create anything new in the law, but it refers to this provision of breaking the lease. So, and of course, what happens after every judge is different, and I think that's one point I'd like to drive home. By being in front of enough judges, everyone interprets everything I'm about to say differently. And there's no consensus, and some judges don't even know what the law is, if you can believe that. So, and some are totally on top of it. But even those that are on top of it sometimes interpret what the law is differently. And I think you have to know who the judge is in those cases. So. All right, so where we are now. So there's at least three laws that I'm going to mention that impact us today. I'm sitting here on August 20th, and things could change on either September 1st or tomorrow, August 23rd, because we're expecting another executive order to come down from the governor. But the latest executive orders from June 11th of 2021 and July 23rd of 2021 really have, well, I'm going to get into that. So I'm just going to tell you what the three are. The other one is Supreme Court rulings that have come out just recently. And then there's the CDC order issued by the president, which I'm sure you've all heard of, extending a moratorium for covered people till October 3rd. So we'll talk about that. There's also municipal, county, and other state mandates. So the executive orders, the latest executive orders that are impacting evictions from the governor. So as on June 11th, this is Executive Order 2021-13, you can now file against, there's no more prohibition about filing against a non-covered person. So there's absolutely no doubt. Any eviction can be filed if it's against a non-covered person. And a non-covered person could be a person who hasn't provided a declaration, as I said before. But then on July 23rd, the governor, rescinded any prior order of the moratorium. And right now, according to the state law, it's open. So you can file against a covered person or non-covered person. But what's confusing about it, at the same time, they're requiring that any filing of an eviction have an attached Appendix A, which I'll talk about later. Appendix A is an attestation by the landlord or attorney that the tenant has been given a declaration. So it creates a certain amount of uncertainty, I think, as to whether or not this is in fact lifted. So where we are. And then also the governor has lifted any moratorium on the enforcement of eviction orders. That would mean like the sheriff or anyone else who would be serving an eviction order. That's been lifted as of tomorrow, well, it's August 21st. So, but then the Supreme Court, in anticipation, actually they issued this before, the governor had announced that he was going to be lifting the moratorium by August. So the Supreme Court on their own issued their own rules, which basically have continued the moratorium. And so there's two. One came out July 15th of this year, and then July 29th of this year. The amended one in July 29th, I think, clarified what the other one wanted to say, but it recognizes that the moratorium has been lifted, but it stays all dispositive motions, trials on the merits, or judgments in residential evictions against covered persons until September 1st. So it extended going forward on a covered person case until September 1st. But then again, it still requires this Appendix A to be filed at any time saying you're given the declaration, which adds a little bit of confusion. So it doesn't, the Supreme Court rule does not prevent, though, however, the filing against the covered person. It apparently not. It's just that if you file it, nothing's going to happen. Now, it's September 1st. because of what's going on with the Delta variant, you know, all of this was issued when things were a little bit different anyways, as far as the rates of transmission of COVID. And I don't know, I've by just looking around and from what I've read, this new Delta variant is kind of taking off. So is that going to affect the governor's executive order tomorrow? I don't know. And is the Supreme Court going to extend their what's called Rule 30370? And as you watch this, you will know the answer. I don't have it with me right now. So, but now they got the CDC order, and that's what I had talked about earlier. And what's interesting about that is that this was issued by the president recently, but it extends the moratorium for covered persons until October 3rd, okay? Now, there's a real question about whether the president had the authority to actually issue this, and he pretty much acknowledged that that was an issue because the Supreme Court is upholding his executive authority on the last edict. Said, Kavanaugh said, I am not going to, if this comes up again and it's extended, I will not vote for, I will vote to deny the executive order. So, anyway, so the CDC order now says it only extends to counties or territories that are experiencing either substantial or high levels of transmission of COVID. And so a week ago, when I last checked, most of Illinois was at the substantial level. 5 counties were not either substantial or high. I checked yesterday, every county is now in the red, meaning it's a high level of transmission. So the CDC order, I would say then, you know, covers all of Illinois. So, okay. And one of the differences with the CDC declaration and the Illinois declaration, Illinois requires that the landlord actually deliver a declaration to the tenant. That's not the case here. To be a covered person under the federal statute, it can be unsolicited, but the tenant, if they provide the declaration, they become a covered person. So I will tell you, though, in my experience, the Cook County judges do not reference this. I have never heard anyone talk about the CDC order and the extension of the moratorium till October 3rd, but what does that mean? So I don't know if they expect it's going to be overruled by then, or what's happening is any covered person case is being continued till after September 1st, which is that Supreme Court rule, but I haven't heard anyone talk about the CDC deadline. However, and also the CDC order says this, a landlord shall not evict any covered person from a residential property while COVID-19 is substantial or high in that county. It says evict, so the question becomes, can you file a case? Can you commence? Other language talks about commencing or actually acting out, enforcing the order of, not order of possession, but eviction order. So here's the thing. So can you after September 1st, with the CDC order, if it's still in effect, can you commence a case? Can you file a case? Can you give a 5-day notice? Can you get the process started? And I am not going to be the one to tell you that you can, because of any violation of the CDC order says that you're subject to a fine of $100,000 or a year in jail for violating this. So it's open to interpretation, and I don't, I can imagine, an attorney in Putnam County or somewhere, Lee County, or sitting in jail, expressing his displeasure with Jack Bailey for telling him he can file an eviction order. So my thought is that you can, but you just got to be careful. All right. So so there's other reactions to the pandemic that the state has done and the county has done. In Chicago, and I know my audience doesn't include all Chicago attorneys, but as of June 15th of 2020, there's a new Chicago ordinance. I call it the Tenants Know Your Rights Ordinance. And what it requires is that when a 5-day notice is tendered to a tenant, it has to have an attachment called the Tenants Know Your Rights Ordinance. And if the tenant reads that attachment, what they'll find out is that if they notify the landlord within those 5 days that they're impacted by COVID, and that they can notify them by almost any means imaginable, but including text and otherwise, then the landlord has an obligation and a duty to try to settle and keep the case out of court. So it becomes an affirmative duty of the landlord to reach out to the tenant and try to work out some kind of a resolution. It also, the 5 days gets extended 7 more days for this process to work out. So a 5-day notice in Chicago, if the tenant responds, becomes a 12-day notice. Within those 12-day notice, the landlord has an affirmative duty to try to work it out. And this ordinance also says what a settlement can and cannot do. You'd have to look at the ordinance. So that's something to keep in mind. That's going to expire in 60 days after the last executive order for the moratorium. Now in Cook County, we have this early resolution program, and it was Judge Evans from Cook County Circuit Court issued this, and the program's been up and running, I'm thinking, for at least a month, and it might be a little more. And it's actually starting to, the difficulties and the kind of the, any kind of problems that there were seem to be kind of working out. There's 6 districts in Cook County. Every district has their own early resolution program, but they're all similar. So, okay. So the early resolution program, so the mandated procedures, it slows down the process greatly, from a typical eviction that you might have been used to before the pandemic. It gets an automatic 1-month continuance after when the case is filed. And assuming you have service on the summons, it goes not to a trial court call, but to a case management call. And every one of the districts has a designated courtroom and judge who handles this influx of all these cases that have come in. There is an early resolution program manager. They're appointed, I think it's through the court system, but they are there because we're doing Zoom still, and that might change soon. But in Zoom, there's always an ERP representative there. So when a case gets called, a judge will look at it, if it's for non-payment of rent, especially, as long as all the eviction papers are in order, you've filed your declaration and this and the other thing, he will refer it to the early resolution program. What happens then is the case gets continued for 14 days. If the tenant is unrepresented, or even the landlord too, but usually it's the tenant, if the tenant is unrepresented, they'll be appointed an attorney to try to negotiate some kind of a settlement with the landlord. They don't typically file an appearance and fight the case in court, but they will work with, within those 14 days, they will contact the other person. If it's an attorney, they'll contact the attorney, and usually with an offer of some kind of resolution. And if that doesn't work, there's a mediation service that's free and available. So after 14 days, the case comes back into court. It comes back to that same case management courtroom. If what the judge hears from the ERP person is that there's no resolution, they couldn't agree, then the ordinance, the rule says that the judge does whatever he wants. That's what it says. So in Chicago, he refers it out to another courtroom. And that'll be for a week later, okay? And then it goes on from there. But he kicks it, and then it just gets dealt with pretty similarly, I'm guessing, to how eviction cases progressed in the past. So, and what's interesting in the first, there's a lot of health and safety exception evictions, as you can imagine, because everyone's looking for a way to get an eviction filed. So people are really getting creative about how to file these health and safety exceptions. So there's actually a number of these cases coming through. And they're putting those, too, in the ERP program. They're getting referred to the ERP program. So, one of the effects of, COVID-19, the Supreme Court has a number of requirements now for when you do file the eviction, what needs to be attached, let's say. So the complaint is required to have a written lease, if there is one, attached to the complaint. A copy of the 5-day notice and an affidavit of service. A copy of an affidavit stating that the declaration was served. Then an Appendix A, which basically is another declaration. Appendix A, you'll always hear a judge say, "Where's your Appendix A?" Well, the Appendix A says why they're not a covered person, basically. So often it's that I served the tenant with the declaration, they didn't return it, cross the box, they're uncovered, but you have to have the Appendix A attached to the complaint. And then another requirement is there's an affidavit of supporting documents. So that has to be attached to the complaint. So your complaints get to be, they can easily get to like 8 to 12 pages, or more. But the affidavit of supporting documents, if you don't have a lease or you've lost the 5-day notice or something to that effect, you have to check off the box in the affidavit of supporting documents, explaining why an attachment isn't there. Or if they all are there, you still need to attach this, but basically you don't check anything off. So, another requirement, and this is something that I don't see any, well, I know of one attorney, but otherwise no one really following. But back in April of 2021, the Federal Consumer Financial Protection Bureau issued an edict of sorts saying that a notification needs to be given with any 5-day notice. And the notification, all it says is, and then there's the language and it needs to be attached to the 5-day notice. All it is, it says that you may be eligible for temporary protection under the laws of your state. And then it gives a website. That's all it is. But of course, it specifically includes attorneys as being people who can, violate that edict from the Federal Bureau, Consumer Financial Protection Bureau. All right, so now I'm going to talk about real quickly well, not quickly perhaps, but the Chicago RLTO, as they call it. Everyone, in Chicago, attorneys that do any eviction cases know it by its shorthand, title, RLTO. The Residential Landlord and Tenant Ordinance. It's been around since 1986. It creates remedies and rights for landlord and tenants. It seems to be more for tenants, and that's what most people believe. There's limited exclusions as to who falls under this. The biggest one is this owner-occupied building where of 6 units or less. The type of things they talk about, habitability, how much notice to be given before an inspection, notifying the tenant of who's the manager or the owner, not certain things you can't waive in a lease, like right to a jury trial, notices of termination of the 5-day. Now, just recently, so I think it was earlier this year or late last year, but it's been extended for a month-to-month or expiration of lease case, where typically you would have given a 30-day notice that your lease is going to expire, and after that date, we can move forward. It's been extended. So if a tenant's been there for 6 months or less, you give them a 30-day notice. If a tenant's been there for 6 months to 3 years, you're required to give them now a 60-day notice. If the tenant has been there for more than 3 years, it's a 120-day notice. So it's something really to keep in mind. And a lot of your tenants may have, or not your tenants, but your client's tenants, they may have been around for a while. So you have to give them 120 days. And if you're late from that, then it's 120 days from the date you actually do give them the notice. So let's say you give them the notice just before the end of their lease. They are automatically entitled to stay now for another, or given protection for another 120 days before you can file an eviction. So now, the Cook County Residential Tenant and Landlord Ordinance, that's a biggie, and it's, big especially in Cook County. So let me talk about that. And it uses as a template the Chicago Residential tenant, the RLTO, the Chicago RLTO. It copies a lot of the very same language from it, but it really adds some different things in there. So it's something you need to be careful. It's not exactly like the Chicago RLTO, but it's very similar in many respects. So it says the purpose of this article is the policy of this county to protect and promote the public health, safety, and welfare of its citizens, to establish the rights and obligations of the tenant and the landlord in the rental of dwelling units, and to encourage the tenant and the landlord to maintain and improve the quality of housing. And what they might have said in it is to put a really huge burden on the backs of landlords, because there's an awful lot for a landlord to follow in here. So one of the first paragraphs of the Cook County tenant landlord ordinance is there's Chicago, Evanston, Mount Prospect, and Oak Park have their own versions of an RLTO. So they keep their RLTO. This doesn't supersede their RLTO. But however, it seems that this is more protective of tenants than what those municipalities usually afford, like Mount Prospect and stuff. So they may decide to get rid of theirs in favor of this, but who knows? So they have the same exceptions pretty much to the Cook County RTLO as is found in the Chicago RLTO, but there's one big exception. So they for the innocent, so what would I call that? But it's the accidental landlord. It's if somebody is renting out a single-family home or a condominium, and if they've lived there at least 1 month for the prior year, and they are not being using a management company, and they're not a corporation, and if it's the only property that they're leasing out, so they're not in the business of being a landlord, they are exempted from the Cook County RLTO. So, under the Chicago RLTO, if you got a condo and you get a job in Florida and you rent out your condo, you're not living there. So you are subject to the entire Chicago RLTO. So this grants an exception for some people, kind of the innocent landlord, someone who's accidental landlord is what I would call them. So. All right. So there's definitions just found very similar to the ones found in the Chicago RLTO as to what is meant. So dwelling unit is very, very broad. You'd have to look at the whole definition. One that has been added is a definition for harassing, and it's really kind of broad, and it could draw some landlords into trouble. Okay, because it says harassing, which is used in some other prohibitions later, says it's knowing conduct which is not necessary to accomplish a purpose reasonable under the circumstances, and that would cause a reasonable person emotional distress to the tenant. And I can just imagine how many tenants are emotionally distressed by their landlord, typically calling to say where the rent is. So so a landlord has to be careful because their voicemails and all that are probably being recorded. So you got to be careful about that and just keep it in mind. Also, this Cook County RTLO is really trying to do away with move-in fees, because what happened in Chicago is people are not accepting security fees, but security deposits because of the problems that the things that can happen that you can get tripped up on. They're calling them move-in fees. So they're making a real effort to limit move-in fees. So one provision here is a definition of a move-in fee. It has to be reasonably related to moving that person in. Further on, it says you have to give an itemized list if you have a move-in fee as to what it entails, like whatever it can be. But it's not to clean the apartment. You can't repaint it, stuff like that. So, one thing One of the definitions that is a little different in Chicago RLTO is that the owner-occupied exception specifically states that it has to be their principal residence. What would happen in Chicago is many times someone would have a cot in their two-flat down in the basement. When they got in a fight with their wife, they would sleep down there once a month, and they'd claim that that was their residence, and it's not. So it has to be their principal residence to have the owner-occupied exception applied to this. So, all right, so also, so there's some mandates as far as the rental agreements, okay? Kind of an additional burden that's put on a landlord. And I would think that most people would want to perhaps consult an attorney if they're going to be writing up leases after June 1st when this took effect. But one of them is you have to name every known occupant in the lease. So oftentimes there'd be one leaseholder. They know that their uncle's living there and maybe even the boyfriend and all this stuff, but they failed to put that on the lease. Now everyone you know, a known occupant, has to be on the lease. And one of the practical things about this from an attorney's perspective is that when you go to file the case, you got to pay for a summons for each one of those named defendants. So you might, and you also have the unknown occupant. So it drives up your fees. So there's a practical problem there. But you have to name every known occupant. You cannot, in a rental agreement, have disparagement clauses. Basically, you can't prohibit typically a tenant from going on social media and saying bad things about their landlord. So kind of a First Amendment issue, I'm guessing. Can't waive a trial by jury. That's what the Chicago RLTO says. You cannot demand the payment of attorney fees in case of noncompliance with the lease, same as the RLTO. Late fees have been actually lowered under the Cook County, the maximum late fees. In Chicago, it's $10 for the first 500 and 5% of everything thereafter. In Cook County now, it's $10 for the first $1,000 of rent, and then 5% for everything thereafter. So if your rent is $1,000, the maximum late fee you can have now in Cook County is $10. Chicago, it's $35. The other thing that's kind of interesting about this section about what could be in a rental agreement, in the Chicago RLTO, you're only liable to 2 times rent damages and attorney fees if you attempt to enforce one of the prohibited sections. In this one, it seems to read that even if you have a lease, and let's say you try to waive a jury trial in there, you are then subject to penalties of 2 times rent. And it's a very easy thing to do. All you do is you go, Judge, look, they did it, you know. So it's not whether or not they tried to enforce it, it's just whether or not it's in the lease. So it's something to be real careful about. All right. Everything in here is prospective, the Cook County from July 1st on, except for things like illegal lockouts and unlawful interruption with a tenancy. So, but for the most part, everything's prospective. So if you don't have to redo a lease if it was entered into prior to June 1st. So, all right. So there's all kinds of tenant rights things. And I'm not going to be able to go over all of this, honestly. It's pretty involved. You're going to need to, if you get the issue, you're going to have to carefully read all of this. One of the things that I would recommend too, though, is there's a summary of both the Chicago RLTO and the Cook County RTLO. I'm getting used to saying that. And if you read it, though, it's pretty well written. They're well written. It'll really give you a good overview of both of these ordinances. So I would recommend anyone to do it. Every time I read the summary, I catch something new. I'm like, what? You know. So it's just good to, if you're doing eviction cases in Chicago or Cook County, to occasionally just refresh your recollection by reading the summary, I think. So, all right, habitability issues lifted almost entirely the same as from the Chicago RLTO. You can't, there's a duty to maintain that's always been, even by case law back to 1972, on a landlord to ensure habitability, but then it becomes what is habitability, and if you if you're not correcting municipal code problems in your municipality or county, then that's, I guess, against the law. There's also habitability standards that are listed here. They go from A through Y, and it's kind of what you would expect. So, elevators have to be structural integrity. Floors have to have structural integrity. Stairways and porches, but you can look at that, and they pretty much mimic what the building code would say in any case. So, and then there's heat, which is the same as what's in the Chicago heating ordinance, I believe it's called, but from September 15th to June 1st, a landlord is required to provide heat 68 degrees during the day, 66 degrees at night. And if you don't, you can recover the tenant can recover 2 months' rent and reasonable attorney fees. Okay, there's also a prohibition against kind of excessive landlord conduct, I call it. What's it called here? It's called tenant right of exclusive possession and to be free from unlawful entry. So it prohibits certain action from the landlord. And if, I'm going to take that back about the heating ordinance, I'm sorry. I was, the 2 times a month is for what I'm about to talk about now, not for the heating ordinance, so. But anyways, so if a landlord makes an unlawful entry in an unreasonable manner, or even makes repeated demands for entry, otherwise lawful, which has the effect of harassing the tenant. And remember, there's that definition of what harassment is. You hurt my feelings. So you have to be really careful. And it's not, you don't even have to go in. You just, if you make too many demands, and I'm guessing it's always about where my rent is, but if you just keep knocking on the door, someone's going to say, I'm suffering emotional distress because you keep trying to get into my property. So, and I've had plenty of experiences where landlords, they do go into the property if they don't think anyone's there, and sometimes you can catch them and take a picture if you're a tenant. So, there's one thing that's new to the Cook County residential tenant landlord ordinance, and I call it the one-time get out of jail free card. And this affords a tenant that any time throughout the eviction process, even leading up to the sheriff coming out and evicting you, if you pay all the past due rent and the fees and costs, the case has to automatically be dropped. So you could be, you can go to trial and you lose your trial. At that point, you can say, Judge, I'm going to pay all my rent. And then the case needs to be dropped, dismissed. So this is the one-time get-out-of-jail-free card for tenants in Cook County. And it's, hopefully if they got the money, then they can, stay in their apartment. So, all right. Well, there's tenant remedies about what you can do for material noncompliance. I'm not going to get into all of it. It's just a little bit involved. You have to provide 14 days notice to your landlord that you're unhappy with, the fact that something's not being fixed. They have 14 days to fix it. If they don't, you can withhold rent, and there's different things like that. So you'd have to read that. It takes a few times to read it, but I could explain it, but it would just be a little bit too lengthy right now. Another thing is this. For the tenant's remedies, one of the things of material noncompliance is if the lease calls for internet service. If you fail to provide internet service, then that could be a material issue for noncompliance, internet service. So, all right. Of course, if there's fire or casualty, like let's say, earthquake or fire, it gives the tenants a number of options. They can terminate their lease. They can move to a hotel and demand payment back. They can, so that's about it. There's a number, obviously there's a number of protections for tenants if something happens to the unit, including terminating the lease. So there's tenant obligations. It's not really a long list. So, but Basically, it's the same as the Chicago RLTO, but basically they have to keep up their apartment. They can't, purposely damage it, of course. In a reasonable manner, they have to, keep all the electrical, plumbing, sanitary, heating in good working order. It doesn't mean that they're responsible for it, but they can't do anything to impair it. But one of the things that's interesting, that's different than the Chicago RLTO, is it says a tenant cannot deliberately destroy, deface, damage, impair, or remove any part of the premises. So it says deliberately. The Chicago RLTO includes negligently. So I guess now if a tenant negligently somehow damages the apartment, they're not responsible for that negligent damage, at least under this ordinance. So. All right. All right. So, and then, there's landlord rights. So what can they do? They can show the apartment. They can make inspections. It's same as the Chicago RLTO. It's 48 hours notice. The inspections have to be between 8 in the morning and 8 at night. The tenant is not allowed to unreasonably withhold, access for inspections. And what is an inspection? An inspection can't be used for harassment purposes, if you just want to inspect every day. But it has to be, reasonable. Okay. And then if the lease is ending, the landlord has a right to show prospective tenants the apartment 60 days prior to the end of the lease. So we have the tenant's remedies. So you have your 5-day notice, which is similar to the state and Chicago RLTO. You also have noncompliance with a rental agreement, material noncompliance with a rental agreement. I think it's important they say material noncompliance, so it's not like something that's just annoying to the landlord. It has to be material noncompliance with the rental agreement. And you are then, if you want to base an eviction on that, you're required to give a 10-day notice. But like the Chicago RLTO, but unlike the state law, it's a cure provision. So really, when you read it, if they don't do it again for those 10 days, you cannot bring a case under that 10 days. And then also, if after 30 days elapse, you can't rely on that 10-day notice anymore. So, couples are having these blowout arguments. Everyone's, complaining of the noise and all that. If they don't do it within the 10 days after they were given a 10-day notice, theoretically, you cannot then bring an eviction based on that 10-day notice. So. All right, there's a whole bunch of stuff about what's deemed abandonment. And it's also always often people will, not often, but sometimes a tenant will leave at the middle of the night. The question is, have they abandoned it? Are they coming back? Can I reclaim the property? Can I rent it out? And so there's a definition of what constitutes abandonment in the Cook County residential tenant lending ordinance. And it's very similar to what's in the Chicago RLTO. But believe it or not, even if they've taken everything out, you have to wait 32 days before you can be deemed abandoned. So, and they also, if they're non-payment of rent, of course, if they're paying rent, it's not, they can live anywhere they want. So, and then there's a description of what to do with property that's left behind. And it gets a little involved, but it's something that you need to read and pore over when a client calls and says, oh, this is what's going on. They left a couch, they left this, what do I do? This will explain what a landlord's responsibilities are and how to keep themselves out of trouble. Interestingly, and this is the same as Chicago RLTO, if you've had a code violation in the last 12 months under the Chicago RLTO, you're required to give notice to your tenant before you lease the property to them. And if not, you can be, they can get 1 month's rent and attorney fees. So we've got to be careful. The bed bugs and lead hazards need to be attached to the complaint. The US EPA notifications, and that's similar to the Chicago RLTO. They also list what happens if someone notifies you as the bed bugs. And it's really, there are some perhaps advantages to the Chicago the Cook County ordinance. And what it is it's a blueprint as to how you need to proceed, okay? So within a certain amount of days, you have to hire a pest control company. And if it's a multi-unit building, you have to notify other units and perform remediation. You have to keep records of all your pest control. And it's all meant really to kind of keep you out of hot water because, bed bugs are big in Chicago, I think. So, in Cook County, I'm guessing. So, and there's going to be a lot of complaints about them. But someone needs to really look at this, a landlord or their attorney or their property manager, and make sure you follow every one of these edicts here, because otherwise you are subject to 1 month's rent or actual damages, and that could be a lot. A lot of times you get bed bugs into furniture and beds and all and mattresses. That stuff all gets thrown out, so it could be more than 1 month's rent, and reasonable attorney fees. So. So I'm going to kind of skip along, but you have to provide a summary, and that's the same with the Chicago RLTO. There is a summary that I had talked about earlier. It needs to be attached to every lease. If not, you get $200 in damages, but also attorney fees. So, you'll find an attorney trying to rack up $30,000 fees because you didn't attach the summary. I don't think many judges will allow that, but you just got to be careful. You might get a goofy judge that does. So, just be careful. You attach the summary to any of your leases. There's a whole provision on security deposits. I'm not going to get into it because I think as attorneys we've all heard, and it's absolutely true, advise your clients not to take security deposits. There's too many traps. And if you don't do one of the many things that are required under the Chicago RLTO in this section, then you are subject to 2 times the amount of the security deposit and attorney fees, okay? A lot of them are gotcha provisions. There's one that's in here that's recently been added to Chicago RLTO, requires you to put the name and address of the financial institution on the lease conspicuously. So if you don't do that, you're in violation. I mean, the court case would be, is this the lease? Yes. And then the judge looks at it. There's no information on the financial institution. 2 times rent and attorney fees. So it's a gotcha provision. And that's one of the reasons why you just don't take security deposits. That's the common thought. And I tend to agree. There's just too many traps. All right. So the retaliatory conduct is kind of the same thing. There's a prohibition against, filing an eviction or not even renewing a lease if the tenant has done something of a lawful nature, like calling the building department or complaining about repairs. If there's a nexus between the two and it can be shown, then it can be considered retaliatory conduct. I have a case now where it's a 10-day notice case, and this is actually in Mount Prospect, and basically they're complaining of my clients fighting at night and that they're getting complaints from other tenants. But what really happened was there was a party that went out till 3 o'clock in the morning in the courtyard, including the building manager who was drinking and smoking and all that. So my client called the police. The next day she got a 10-day notice, and she had just moved into the property a few days before. So that can be perhaps considered retaliatory conduct. You just got to keep an eye out for that. So prohibition against lockouts, similar to the Chicago RLTO. So not sure where we're at time. All right, so let's go back to, so that's the the Cook County residential tenant and landlord ordinance. And I'll get used to saying that. So, all right, here's a really big deal, I think. So with the status of evictions, is rental assistance. What's going on? I read that the federal government has allocated $47 billion in rental assistance, and I know that it hasn't all been distributed. I mean, it hasn't. Exactly why, what the problem is, the staffing or whatever, it's just been a real problem. It's not getting to the landlords. It's just been moving at a snail's pace. And it's the reason why I think the CDC extended the moratorium until October 3rd because they want to keep this open, so the tenants, can pay their rent and the landlord can get paid, and there's not going to be an eviction. They're trying to stop an influx of evictions once the moratoriums are lifted. And I think that's what the CDC thing does. And I think that's what the Supreme Court rule is too, when they extended the moratorium until September 1st. I think the whole idea is to get this thing working. Now, I talked to someone from the Lawyers Committee for Better Housing yesterday, and I asked them what's the status of rental assistance. As of yesterday, there is none right now. I mean, the money is out there, but there's no way to make an application. The only application that can be made is through one of these nonprofits. They have a fund for them to access it, but it used to be a landlord was at one point given the opportunity to apply for it themselves in the first instance, but that's no longer the case. But a tenant on his own cannot, at this moment, cannot apply for rental assistance. However, that is going to change because there's a lot of money out there, and it's going to be distributed. And that's what I think the thought is, that once all that money starts coming in, there isn't going to be this flood of evictions that everyone's worried about. So it may or may not work. I mean, it is happening. It's trickling in. I have some cases where my landlord has gotten paid, and boy, are they happy. So, all right. So I think that's about, I'm going to wrap it up. So what's the future of eviction cases? I think a lot of what we're talking about, the moratorium is going to go away at some point. If not, by the time you're watching this, I don't know. But a lot of these other kind of programs and requirements and tenants' rights that have been granted during this pandemic are going to last. I think the nature of an eviction case is going to really be different. I mean, they're summary proceedings, and before the pandemic, they, by most judges, were handled in a very summary manner. But now there's so many requirements to even filing an eviction that's going to continue. So you have to attach the lease, you have to attach these affidavits, you have to attach the 5-day notice. And whether or not people are going to comply with that, I don't know. But I see that going forward. I also think in Cook County, this early resolution program, it's not sunsetting that I'm aware of. And how long it's going to last, I don't know. But it really changes the dynamic of how an eviction proceeds. You don't get your eviction order on the first day up. So it's much more of a process now, and it's really for the benefit of the tenant. So, and that's what I think that's what we're going to get out of this going forward. So it's very likely that either the governor or the Supreme Court might extend the moratorium. We'll know in a few days. But we'll see. That's the future. I do think it's going to have an impact. And when it gets back to how it was prior, with the summary evictions that would take place like this, I don't know if it'll get back to that point. But one last thing I'm going to say. So given all of these laws that I've talked about and everything, it increases our value as attorneys. I mean, basically, it was that landlords in the past often could successfully file their own eviction, but it's very difficult now. And I think it's going to continue to be difficult, even after the moratorium is lifted. So we're giving more value to the customer. And actually, if there's a bright spot in this, it's that we can provide more value to our clients, and more attorneys are going to be needed in the eviction process. So,
Jack, one question. Are there any restrictions on commercial evictions?
no.
So they're wide open.
It's wide open. The only thing is when you file a commercial, you have to attach the Appendix A saying why it's excluded from the moratorium, and it'll say it's a commercial. And so you have to attach that to the complaint. And also, it's best to really highlight that it's a commercial eviction because it'll be treated entirely differently. But otherwise, no impact. So.
Great, thank you.
All right.